and I ended up choosing the Air Force. I thought the Air Force was more my thing.
40 odd years later, you're a barrister in Sydney.
I applied to them in 2011 to join the Specialist Reserve as a reserve legal officer. Often people who aren't lawyers ask, well, why don't they just stop country X from doing such and such? Or why don't someone say you can't do that when it comes to imposing tariffs, for example? Australia takes a very strong, robust position that of absolute paramount concern is compliance with international law. So we go to extraordinary lengths to make sure that anything Australia does is absolutely compliant.
Pleased today to welcome Richard Gration to sit with me and have a conversation about effectively the law of war, as I would call it, or the law of armed conflict. Now, Richard has a very strong familial history and connection to the ADF, don't you, Richard?
I do, yes.
And how is that? How's the strong familial connection developed?
So my father was in the Army.
Yeah.
Had some 45 years or so in the Australian Army, joined straight out of school, went through Duntroon, and then had a career in the Army, ultimately rising to the position of Chief of the Defence Force.
Which is, in my view, a ridiculously big achievement for a man. So how did he ultimately become the leader of the whole of the Australian Defence Force, as far as you can recall?
Look, as far as I can see, because I was obviously a child for a lot of this while he was growing up, he just did a series of postings to different places that prepared him for ultimately that ultimate leadership position.
Yeah.
So he did things like going to the UK Staff College for UK Army officers to train when he was a major. So that set him up with all of his initial staff skills that he needed to start working towards those senior leadership positions. He was also the first Australian who ever went to the United States Army War College, which is in Carlisle, Pennsylvania, where the US trains its future generals. When he came back to Australia, he was then promoted to brigadier or brigadier general, as the Americans would call it, a one-star position, and then went through a series in rapid succession of leadership positions as a general, and became then initially the Chief of Army, a three-star general position, and then was selected from amongst the three services to become the four-star, the Chief of Defence Force.
Wow. And how did being in the family affect your sort of move towards becoming an Air Force cadet in 1981, which is now
it was
45 odd years ago?
Slightly tricky.
Really?
My father's brother, his younger brother, my uncle, was in the Air Force, and he ultimately rose to be Chief of the Air Force, the three-star position. So it was very much a family business.
Yes.
When I was a teenager, I was very interested in aviation and aeroplanes and flying, and I lent much more towards the Air Force side of things.
Okay.
Bit of family tension there. My father would much have preferred, if I was going to join the forces, to join the Army.
Yes.
And in fact, I applied and was accepted to go to the Royal Military College at Duntroon. And I also applied and was accepted to go to the Air Force Academy, which at that time was at Point Cook in Melbourne.
Yeah.
And I was in the fortuitous position in year 12 of having a choice. I could have picked either of those to go to once I graduated from high school. And I ended up choosing the Air Force. I thought the Air Force was more my thing. And particularly, I was looking forward to being able to fly. The structure the Air Force has, or had then and still has now, is the first 3 years doing academic studies. So I did 3 years doing a science degree, studying physics, nuclear physics, quantum mechanics. I did a little bit of computer science in there as an elective because I was personally interested in that. And then in the fourth year, it's flying training for that year, and then graduate after 4 years as a qualified pilot, ready to go out there and start flying.
Okay, so now, 40 odd years later, you're a barrister in Sydney. We share chambers together, obviously.
We do.
But since 2011, so for the last 13 years, you've sort of come back to the military after a period in the early stages of your career, and you're now in the specialist reserve legal team of the ADF. Can you?
Yeah, that's right.
Yeah.
So once I'd done my legal studies and started working as a barrister, I always very much enjoyed the time I had in the Air Force and was very keen to get back and do some more work with them. I thought that my aviation experience coupled with my legal experience would be valuable to the Air Force. So I applied to them in 2011 to join the Specialist Reserve as a reserve legal officer.
Because you were a barrister by then.
Because I was a barrister by then, became a barrister in 2009.
Yes.
So I joined reactivated my service back in 2011 and became a legal officer in the Air Force, which I still do to this day. So I'm still presently a reserve legal officer.
Now, somewhere I've read on your CV, there's a specialist, a label specialist about the reserve legal team. Is that something to do with the specialisation of law within the ADF, or is it a branch of the ADF that's a specialism, or is it more just a sort of a summary of your role in the ADF now?
So the Defence Force generally has reservists.
Yes.
There are some of the areas that are classified as specialist reserves. So most reserves are general reserves and can do essentially any tasks.
Okay.
Specialist reserves are people like doctors, dentists, lawyers, and so forth. And they're categorised as the specialist reserve. So the legal officers are one of those that are specialist reserves. I mean, it doesn't have a lot of practical consequences, reservist to reservist, but for example, a general reservist is required, generally speaking, to provide 20 days of service a year.
Okay.
A specialist reservist is only required generally to provide 7 days a year, in recognition that a lot of specialist reservists, if you're a cardiac surgeon in your real life, you probably haven't got enough time to be going and spending 20 days a year doing reserve service for the military.
Sure.
So it's an acknowledgement that people in those professions often don't have as much time available as a general reservist might have.
But it's still very much a wish of the ADF to have people in private practice involved in the ADF.
Oh, absolutely.
Yes.
And at the moment, with Australia's strategic circumstances becoming more complex and difficult, we see in the next 5 to 10 years, there will likely be a much greater requirement for lawyers.
Really? Well, there's also, I mean, there's a lot in the news about been a lack of recruitment into the ADF generally. I mean, we'll come to lawyers, but is that still a concern, do we think, for the ADF, leading to them trying to recruit New Zealanders, for example, into our forces?
Yeah, very, very much so. So it's no secret the Defence Strategic Review that's out there, it's a public document, people can go and have a look at it, which looks at our changing geopolitical circumstances. All of your listeners will be aware of the difficult circumstances the world finds it in at the moment. As a result of that Defence Strategic Review, the government has accepted the recommendations and is increasing the size of the Defence Force. It's increasing the size of the defence budget. That involves recruiting more people. And at the moment, again, it's no secret, it's out there before Senate estimates committees and the like, that actually ramping up and recruiting an extra 7,000, 10,000 people to join the Defence Force is difficult and takes time. And particularly in the skilled areas, it takes 4 years before you've got someone who has the sort of skills to be able to go out and fly aircraft, for example, at even the most junior level. So you can't suddenly find a whole bunch of F-35 pilots overnight.
No.
And in other areas, if you can recruit people that are pre-trained from New Zealand or elsewhere, that's a good option to be able to get people quickly that have the skills. Other areas, such as our nuclear-propelled submarines, we're looking at maybe a decade to get the level of skill and expertise that we need. Australia doesn't find a whole bunch of nuclear engineers overnight in a country where we've got no history and background of nuclear engineering. So getting not only nuclear engineers, but most importantly, academics who are qualified to be able to teach the nuclear engineers is a huge undertaking.
Well, it's fascinating, isn't it? Because last weekend in the news was the publication, I suppose, of the connection between the UK now and Australia in relation to AUKUS and nuclear submarines. So as a member of the ADF as well as an Australian, is that something that gives you comfort around our future protective capacity?
Yeah, absolutely. So Australia is a middle power.
Yeah.
We've only got 26 or 27 million people. We are certainly not one of the big players on the world stage in terms of military strength, in terms of economic strength and so on. Necessarily, Australia needs to act in concert with other like-minded nations in order to look after our strategic interests. And the UK, because of the long history between Australia and the UK, is very much one of our key partners. The AUKUS treaty, Australia, UK, United States, was very important, or is a very important military arrangement, which effectively seeks to cover the globe from the Indo-Pacific through to the Atlantic, with the countries on the three sides of that. The most recent treaties between Australia and the UK should be seen as part of that framework of the Australia, UK, US. And again, it's no secret the US is having difficulty meeting its own submarine production requirements. They need to be producing at least 2 or maybe a little over 2 Virginia-class nuclear submarines each year to meet their own needs. They're not currently doing that. So necessarily we need to be thinking about how we can assist in getting that production up, and also keeping in mind that the Virginia-class submarines from the US are only the initial phase of what's envisaged under AUKUS. The sort of steady, mature phase of AUKUS is with a purpose-built, purpose-designed submarine designed in the UK, the AUKUS subs.
Can I ask you there, because there's some public concern, or at least as a member of the public when we read the paper, concern comes around the AUKUS treaty where, just as you've just said, that the US almost doesn't have the ability to deliver for itself what it needs. So how on earth is it going to help us have what we need? So is that a genuine concern? Is that what, and do you think politically, I appreciate we don't want to comment on politics, but has that got something to do with the way the Australians have become perhaps a little bit more obvious in their connection with the UK in the last few weeks?
No, I think it's just part of the broader expectations under the AUKUS treaty.
Okay.
The United States and Australia have historically always been and continue to be very close partners. Australia and the UK, that effectively were settled by England. We have that very strong historical tie going back with England, and the UK is also a very strong, long-standing ally of the United States. So you've got 3 allies who are working together cooperatively. We share intelligence information, the Five Eyes arrangement as it's called, Australia, Canada, UK, US and New Zealand. The 5 partners have been very close strategically, cooperatively for many decades. So it really is just part of that arrangement of continuing that very collaborative working arrangement with them. And while it is obviously a concern that the US industry, they make no bones, they need to ramp up their ship production capability or submarine production capability. And Australia is assisting at the moment in trying to ramp up that production level to enable, for the benefit of all 3 partners, to get more submarines being produced.
And as a member of the Defence Force, how much of this information that you're able to share with me is able to be understood by a member of the force and by an employee of the government through the channels that come down from the government to the chief and below, rather than what I am only able to obtain through the media? Is there a strong line of communication so the whole force understands this sort of stuff, or is it a bit patchy?
No, so the whole force understands. There's regular communications internally in the Defence Force, providing information and updates on it, but that at the unclassified level is exactly what the public is seeing.
Yes.
So you can go to the Defence Force website, you can read on the Defence Force website if you want to read all about what's happening with the project, what's going where, all of those sort of things are public information that's available.
Okay, thank you. So going back a few minutes, you spoke about the fact that there's going to be a recruitment drive, or as we move forward in life, there's going to be a need for more and more lawyers in the ADF. Now, to some people, that's got a bit of a grown mentality of, oh, not more lawyers. But what is it, do you think, that's evolving that means that people with legal training and legal practitioners are going to be required as recruits for the ADF?
So the ADF, like all Western countries, is very firm in the acknowledgement of the importance of the rule of law.
Yeah.
The rule of law is essentially what keeps the world at large operating in the way that we've become accustomed to. So if you delve a little bit back into history, World War II was the last global conflict involving effectively the whole world. And at the end of World War II, the nations of the world said, never again, this is terrible, we've got to come up with a better way of organising ourselves. And out of the ashes of World War II, you saw the formation of the United Nations, which was an evolution of the former League of Nations, which had the right sort of ideas after World War I, but wasn't entirely successful. So the world had another go, and indeed Australia was a key player in some of the initial arrangements. Doc Evatt setting up or contributing from Australia's perspective in the setup of the United Nations led to the creation of the UN Charter, which is the sort of key foundation document for the modern world order. That gives the primacy to having a legal framework and sorting out disputes instead of, as it happened in World War I and World War II and indeed for thousands of years before that, sorting out disputes by the use of force and military power. The focus of the United Nations Charter is that nations must conduct their relationships peacefully and providing a forum in which to resolve disputes without having to resort to the use of force.
Can I stop you there? So just because this conversation is for the purpose of sort of demystifying law and lawyers and the legal system, how does that United Nations Charter and that what appears to be and sound like an agreement between states differ from, say, a domestic law that people are bound by or a state law?
That's a great question. And often people people who aren't lawyers ask, well, why don't they just stop country X from doing such and such? Or why don't someone say you can't do that when it comes to imposing tariffs, for example?
Yep.
So international law is fundamentally different to domestic law. Domestic law is imposed on you without your consent. You're just subject to it. You're born in Australia, you're subject to Australian laws. You don't get a say in it.
And if you become a citizen because you acquire citizenship because you move here. And so
you acquire citizenship and you move here, if you live in Australia, or indeed if you're a visitor and you're physically in Australia.
You're bound by law.
While you're visiting Australia, you are bound by Australian laws. It's non-consensual. You have no say in it. That's the way the system works.
It's not an agreement. Well, I suppose the agreement from a visitor is a person who's agreed to come here and then they become bound by the law. But if you're born here, it's not an agreement. You're just born here.
You're born here and you live here. That's
exactly.
right.
Yeah.
International law is the complete opposite of that. There is no world government. There's no world police force. There's no world organisation that imposes laws or decides laws. On international public law, you are only, generally speaking, bound if you have agreed to be bound. So there's three sources of international law. The first source people are relatively familiar with, which is treaties, documents, where countries sign an agreement between themselves that they will behave in accordance with particular requirements.
Can I stop you there? So that treaty, who writes that?
So the countries themselves write that.
Okay.
So if you wanted to have I'll pick some of the historical examples. If you wanted to be able to post letters between different countries, how's that going to work? Well, the countries get together and say, okay, if we want to be able to send and receive letters between each other,
this is how we'll do it.
This is how we'll do it. And we'll need to come up with an agreed standard and how we'll make the system work. So like-minded countries come together and say, well, let's negotiate what we think that contract should look like or that treaty should look like. And then they'll agree a set of standards so that you can post a letter in Sydney, Australia, and it will ultimately get delivered to Afghanistan.
So the United Nations Charter then is obviously it may not be a huge document, but it's a a written document.
It is a written document.
Somebody after Second World War must have sat down, a state, and started with the first draft, and then that would have been conveyed around the various consenting countries until everybody landed on a form of it.
Yes, exactly. So not started by a state. It was the initial discussions were dozens of states who came together and said, look, we need to come up with a new fundamental treaty sort of governing international relations. And the United Nations Charter came about as a result of multiple conferences, lots of countries putting in what they want. International law inevitably ends up being a big compromise.
Well, and even in that, I assume that from each state's point of view, you're going to have a bunch of representatives who are both bureaucrats and lawyers acting with bureaucrats, but also a very strong political undertone of all of it.
Yeah, absolutely. So pick another well-known example, the United Nations Convention on the Law of the Sea, UNCLOS, is another key treaty that sets out how you determine where a nation's boundaries are. And it has what very well known is that 12 nautical miles out to sea is how far a nation's sovereign territory extends. That is one of the most universally accepted treaties, perhaps other than the United Nations Charter itself. But UNCLOS, the United Nations Convention on the Law of the Sea, was negotiated in the 1970s and the 1980s, trying to get agreement on it. And almost every country in the world agrees that that's how national boundaries should be determined.
So on that then, because of course, I mean, I think it would be fair to say that from media reports with a whole lot of activity in the oceans and various forces going in different locations and some recent commentary about military ships off our shores, is it we should accept, should we, that as a matter of legal reality, beyond 12 kilometres from the shores of the Australian continent, it's sort of fair game for anybody to pass through and do what they want? Is that
yes?
Is that what we should accept?
Yeah. So within 12 nautical miles, that's Australian territory.
Yes.
Once you get outside 12 nautical miles, there's another zone out to 24 nautical miles where Australia can exercise customs and immigration control.
Yes.
And then out to 200 nautical miles or to the end of the continental shelf, it's what's called the exclusive economic zone. Yep. So a country has rights to exploit the economic value of the oceans exclusively
within that 200
nautical miles.
And then, where's the boundary? And I don't just mean physically, but between states where other people would come within that without, say, express consent of the government. Is there a boundary there, and is that what leads people to comment about it in the media?
Yeah, so under that convention, a government can exclude people from coming within 12 nautical miles with some exceptions. Shipping is allowed to sail in transit passage through those 12 nautical mile waters.
Yep.
So the government can't stop someone transiting without stopping and behaving without firing missiles and launching aircraft and things like that. If you have a commercial ship, it's entitled to sail through those waters.
Okay.
It also has a huge impact on aviation, that airspace essentially follows the ownership of the ground below. One of the big differences between air and sea rights is, although there's this innocent passage concept for ships transiting through a nation's territorial waters, there's no equivalent right for aircraft. So if an aircraft wants to come inside the 12 nautical mile boundary, then the aircraft has to get permission from the country.
Okay.
And a country has the absolute say-so. They can say, yes, you can, or no, you can't come through. And if another nation flies their aircraft within that 12 nautical mile boundary, that's technically a breach of sovereignty of the nation state.
Okay, thank you. And then and again, I keep interrupting you, but back to the United Nations Charter and the rule of law and international law. Just how has all that evolved since when it was became law after the Second World War?
Yeah, so treaties we started talking about negotiation of the treaties. The treaty, you get lots of like-minded countries come together. There's a lot of argy-bargy and discussion, and countries will say, well, I can't accept that. If you put that in, I won't be signing the treaty. So there's quite a negotiation process that goes on to come up with an agreed form of words. And that can sometimes take years, many years, to get everyone to agree to the form of words that they're willing to sign up to. Once an agreed text has been reached, states will sign up to the treaty. Whether that becomes binding on the state depends, ironically, on national law. So some states, the executive branch of government has the ability to enter into a treaty, and that's that.
Yes.
Other nations, other states, it needs to be ratified by the Parliament. So the United States is a very well-known example of that. Yeah. Although the President of the United States can sign a treaty, unless Congress ratifies the treaty, it's not binding on the United States.
And is that the same in Australia?
No. So Australia, the executive arm of government, can sign up to a treaty.
Okay.
If it does impact domestic law, it's not effective in domestic law until such time as Parliament has incorporated it into domestic law. But Australia as a nation can be bound by the executive government. So it does mean that Australia can sign up to treaties and it's not subject to Parliament saying, yes, we agree that you should do that. So you've had all of these parties come together. United Nations Charter, for example, there's some 194 thereabouts parties to that treaty. Once that's signed up, all of those parties have agreed as between each other that they will comply with the requirements of that charter. And so, for example, there's in Article 2 of the United Nations Charter, there's a prohibition on the use of force. It is forbidden to use force against another state or to interfere with another state's sovereignty.
So can I stop you there? Because that would be a reflection of trying to put Second World War behind everybody. But obviously the whole of the Second World War and what's happened in many places since has been the use of force by countries against others. And we don't need to name who they are because it's happened over the last 75 years since the Second World War anyway. Yeah. So, but it's more about, so if there is then a use of force, that's a breach of that convention if that state or territory is a member or a signatory to the convention.
Which is essentially everybody.
So but then does that mean that's then a breach of international law to use force? Is that as fundamental as it becomes?
It's slightly more complex than that.
Okay.
So there's a prohibition on using force against another state. The main, most commonly used exception is Article 51 of the United Nations Charter, which says a state's entitled to defend itself. Okay. So there's a self-defence provision that says if you need to defend yourself against an armed attack from another state, you're entitled to do so.
Can I stop you there? So if we go back to the prevention of the use of force, in Australian law and in domestic law, if there's a breach of law, then there's a punishment or a remedy is probably not the right word, but a punishment or a sanction. So before we get to Article 51, for the use of force, is there a punishment? Is there a sanction or a consequence before we get to the analysis of whether or not self-defence is able to be used?
Sort of.
I thought that might be the answer.
So Chapter 7 of the United Nations Convention deals with the Security Council.
Yep.
So the Security Council, when the United Nations was set up, is a separate body to the General Assembly, which is all of the members of the world, all 194 odd states. The Security Council is a council of 15, sort of like the executive body, if you like, of the United Nations. The Security Council was established with 5 permanent members: the UK, France, United States, Russia, or at that time the Soviet Union, and China. The other 10 positions are rotational and they get voted on each year by the General Assembly, and countries will have then a term on the Security Council. So that Security Council is the body that under the Charter, the UN Charter, has the ability to impose sanctions and to authorise the use of force. So you'll often see bodies are set up pursuant to a United Nations Security Council resolution.
Yeah.
So, for example, close to Australia, when East Timor was finding its independence, the United Nations established a task force that went into East Timor to ensure the peace and to make sure the transition to East Timor becoming a sovereign state, its own separate country, went smoothly. So the United Nations Security Council is the body that can do that.
Okay.
In the first Gulf War, when Iraq went into Kuwait illegally with the use of force, the Security Council passed a resolution authorising the use of all necessary force to expel Iraq out of Kuwait.
Okay.
And that was the basis of countries going in during the first Gulf War, was pursuant to a Security Council resolution.
So that's an action that the Security Council authorises and presumably brings forces from all the members together to achieve. It's not so much a punishment, like if there's a commission of a crime in Australia, obviously there's a punishment and a sanction. So it's a form of sanction, but quite different than, as you've said from the beginning, from domestic law.
And you've also got to think about how do you punish a country.
Exactly.
So you can't
That's the
lock them up and
difficulty
put them
of it.
in jail. So the sort of punishments, if you want to call it a punishment, is, well, we're going to authorise the use of force to stop you doing whatever it is you shouldn't be doing.
Yeah.
The Security Council can also make resolutions to impose sanctions, which they've done numerous times in the past. And they can say, well, until you behave properly, we direct that no other country should have trade relations with you, for example, bringing economic pressure to bear. So that's... if you want to call it a punishment, is how punishment works, is the Security Council come together and decide collectively. It is very well known that the Security Council, with the 5 permanent members, each of those permanent members has a veto vote, which means in practice that very often the Security Council divides along ideological lines. You have 3 Western countries, Australia, the UK, the US and France, who are the Western aligned countries, and you've got the Soviet Union, now Russia, and China, who are the non-Western aligned countries. And there is very often a deep divide about what they're willing to do, and any one of those 5 can veto resolutions. So in relation, for example, to the war in Ukraine, Russia has very obviously used its veto power and said there is not going to be any action taken against Russia for using unlawful armed force against a sovereign state,
So
that is against Ukraine.
That kind of leaves the Security Council's effectiveness in delivering what it was set up to do somewhat.
Yeah, so when you say
ineffective.
defectiveness, when you look at over the years, it's now, 80 years since the end of World War II. For all its faults, the United Nations and the Security Council has been very effective at preventing the outbreak of another global scale conflict.
Yes.
There's certainly been lots of regional conflicts, and, the Middle East and war in Vietnam and places like that. There's obviously been a smaller scale, but there's been very effective in stopping a full-blown World War II style global conflict. In a sense, it does lend a sense of balance that with the 5 permanent members, something has to have very broad agreement before it's agreed. You get then necessarily countries being forced to compromise in order to be able to get things through. And if you do get something through the Security Council, and they've made thousands and thousands of resolutions since 1945, if something does get through the Security Council, then it does have broad global support.
And it would be extremely effective in preventing or achieving what it's set out to do.
Yeah, and so Gulf War I is a good example, that the world at large was so horrified at Saddam Hussein unlawfully, without any valid reason, marching in and invading Kuwait, that the world at large said, you can't do this. We authorise the use of all necessary force to eject you from Kuwait. So that was a good example of the Security Council actually working.
So then the aspect of self-defence, you mentioned Article 51. How does this interpretation of self-defence inform whether somebody is actually breaching the first or the second article in relation to use of force.
And it's a really good question and a really tricky area. The Article 51 allows a country, a state, to respond to an armed attack. What constitutes an armed attack?
May I ask you, are those the exact words in Article 51, an armed attack?
Yeah, look, let me get you the exact words so that we're talking to the same thing. So Article 51 says nothing in the present Charter shall impair the inherent right of individual or collective self-defence if an armed attack occurs against a member of the United Nations until the Security Council has taken the necessary measures to maintain international peace and security.
Okay, so armed attack, from a legal point of view,
there's a lot of law around that.
There's a lot of law in that. Two words, very powerful words, and together even more powerful, and that would lead to all sorts of different interpretations, I'm sure.
And it's led in the modern 21st century to what is now termed by international lawyers and international military strategists as grey zone warfare.
Grey zone warfare.
In the grey zone, somewhere between peace and somewhere between a full-blown armed attack.
And is that all just, not all just, but is it around the interpretation of those two words? What constitutes armed and what constitutes an attack separately, and what the two words together mean?
Yes, so some cases an armed attack is very obvious, a kinetic attack, such as Russia undertook against Ukraine, where you've got missiles flying. That's very clearly not grey zone.
Right. That's a little bit that's more obvious.
What is far more difficult is if one state uses cyber warfare techniques to manipulate the computer systems of another state. And for example, if one state, pick up a random made-up example, took control of the computer that controlled the floodgates of a dam and opened the floodgates of a dam, masses of water come down into the valley, wipe out thousands of people and homes and factories and so on below the dam. Is that an armed attack? All the country has done is altered some ones and zeros inside computers.
How could, on the ordinary meaning of armed, how could that be?
That's right. Is it an armed attack?
And is it even an attack? I mean, I think understanding the word attack, that has more possibility of being understood to be relevant in that situation. But the word armed still is interesting. And
exactly. And that's where a lot of the disputes arise in the modern days. People, no, we haven't committed an armed attack. You have no right of self-defence. So working out exactly what constitutes an armed attack, and generally the international law community has settled on things that have kinetic effects in the country.
Okay, and by kinetic, can we just explain?
Kinetic in the terms of breaking things, of damaging things in the country. So things that merely cause inconvenience. So for example, pick a well-known example where Australia's Bureau of Meteorology computers were hacked, so that the Bureau was unable to issue weather forecasts effectively and in a timely fashion. This was going back about 5 or 8 years, I think.
Which is a lot more than just inconvenience. It might sound inconvenient, but actually it has some very serious consequences.
It could potentially, but the direct effect is massive inconvenience to things like your airline industry.
Yes.
If you can't issue accurate and timely weather forecasts, it has a big effect on aviation. Is that an armed attack? Well, it's certainly inconvenient. It certainly has an economic consequence, but is it an armed attack? Does it have this kinetic effect? And so that's why the term used is grey zone, because it is unclear and deliberately unclear on the part of those undertaking it whether it does give rise to a right of self-defence.
I mean, does it mean, and again, it's a bit of a side question, but does it mean that the expression armed attack that was obviously formulated 70 years ago,
before computers,
is out of date? Or is there must be a live argument that that expression could be broadened or opened up to be a lot more liberal in order to accommodate the grey zone?
Yeah, so it then comes down to, which we haven't yet got to, secondary sources of law. So we've talked about treaties as one of the sources of law, and the UN Charter is a key treaty that really is the foundation of almost everything else. The second source of international law is what's called customary international law. So these are practices that are so widespread that everyone treats them as, look, it just goes without saying that this is the law. So there are customary conventions that, even though they're not written down, are considered to be binding. It's a little bit like the common law
yes.
in common law jurisdictions. It may not be written down in an act of parliament, but it is treated by the courts as being something that is binding on everybody.
Well, it's evolved over time in answer to circumstances, and people become then aware of principles that they accept to be bound by.
Yes, and the United Nations Convention on the Law of the Sea, although it's a treaty, the one glaring omission, the one state that you would not expect not to be a party to that, is the United States, which is very surprising. This UNCLOS, the Convention on the Law of the Sea, is so widespread that even though it's not, the United States is not technically a party, it is treated by them as customary international law in the sense of the 12 nautical mile boundaries, the contiguous zone, the 24 nautical mile boundary, the 200 nautical mile exclusive economic zone boundary have become so widely adopted and accepted across the world that the United States, even though it hasn't signed that treaty, treats that as now customary international law, binding whether or not you've signed the treaty. So you've got that secondary source of law of things that are such widespread practice that it's accepted by the world at large that this is binding on you whether or not you've agreed to accept it. The third source of international law are decisions of international courts, international juridical bodies, and the writings of international law scholars.
Yes.
They also can be a source of the law. And so when you come to the grey zone conflicts, what actually constitutes an attack or an armed attack, the world has effectively developed through customary practices what is taken to accept that. So historically, border skirmishes are one. Is that if one soldier on one side of a disputed border in Kashmir fires off a round from a rifle, is that an armed attack? Has it got the scale? The world says, well, no, look, that's one rogue fool setting off a rifle does not constitute an armed attack on the state. So there's some understandings of what have come from that. You also get nations come together to write what are called manuals, which are not treaties so much as they're in the third category of sources of international law, the writings of experts in the field. So one of the very important ones is the Tallinn Manual, Tallinn, Estonia. It's called the Tallinn Manual because that's where the conventions have been held where states come together and discuss it. So the Tallinn Manual deals with cyber warfare. So it sets out in quite some detail what different states consider to be the law. And the Tallinn Manual is a very good example. If you look at it, it sets out what the majority position is, what the dissenting position is. It doesn't actually purport to be a treaty which nations have signed up to. It sets out what effectively the different participants in the conference or the convention think that the law is.
Okay, so that is not unlike judicial decisions in Australia, where it's not actually a specific finding in relation to specific facts. It's more an evolving set of principles that people become accepting of.
Yes, exactly.
States become accepting of.
And it becomes ultimately a document that international courts will look to say, well, what is the consensus of opinion? If I cyber attack your dam and cause the sluice gates to open and cause massive death and destruction, is that an armed attack? So you can go to the Tallinn Manual and see what the differing opinions are.
Okay.
And so that's...
Sorry, Richard, is Tallinn an abbreviation of something?
Oh, so Tallinn is the capital of Estonia.
I see. And Estonia is not the original source of this. It's just...
That's happened to be where the conference was held.
Formulated. Okay.
Yes.
Okay.
So that's where people gathered to discuss it. So Australia has sent representatives over time along to that conference. We've developed in Australia the Woomera Manual. It's a joint project with the University of Adelaide, trying to get a statement of what the law in relation to space is. So the Woomera Manual is Australia's attempt to bring countries together to try and agree on what the laws of space are.
And Woomera presumably is a town in South Australia.
Yes.
Woomera, I think I've heard of it. Yes. Okay. And so it's just where the meeting or the...
Well, so the meeting was in Adelaide, but it's referred to as the Woomera. It's an area outside Adelaide, just famously used for nuclear tests by the UK in the 1950s.
So back then, Security Council and then International Court of Justice, you've spoken of international courts, I think we see it in the paper as the ICJ, it's the International Court of Justice, is the constitution or the formulation of that derived from the Security Council?
It's derived from the United Nations Charter.
Okay.
So the ICJ is effectively the world court that has been established under the auspices of the United Nations to rule on international disputes. So if you want a ruling on whether something is lawful or unlawful, where you go to is the ICJ, the International Court of Justice, and argue your case.
And on that, though, is that, like, we have the High Court of Australia, we have 7 judges, we have a Chief Justice. Is there a panel of judges that's of any number, and is there a chief, and how does that whole entity work?
Yes, there are a panel of judges. So typically in significant cases, they'll have 20, 22 judges who will sit. Deliberately, they make an effort to make sure that the judges who are sitting on a particular case represent the spectrum across the world. So you'll have Western nations will be represented, African nations will be represented, South American nations will be represented, and so on, so that it's not just the United States or Canada or the UK or France who get to dictate the outcome. All countries get to be represented in the ICJ.
Wow. And is the ICJ the body that then issues, or there must be some other body that issues arrest warrants, for example, for rogue individuals or rogue states that the Security Council says it's time to do something about conduct? So
the arrest warrants, and what you're perhaps alluding to there, is the International Criminal Court, which is a separate court, and that's established under the Rome Statute. The Rome Statute deals with essentially with war crimes and preventing those international criminal wrongs. Under the Rome Statute, which establishes the ICC, International Criminal Court, the ICC has a process. The chief prosecutor, if the chief prosecutor, he or her, thinks based on evidence that there's a case to answer, they can issue an arrest warrant. Well, in fact, it's not quite right. The prosecutor doesn't issue the arrest warrant. The prosecutor applies to the court. Some judges look at the evidence and say, effectively, is there a prima facie case? Does it appear, without determining the matter, that there's a case to answer? If there is, they'll then issue an arrest warrant for that individual to be brought before the court. So in the conflicts that we saw in Yugoslavia a decade or two ago, the International Criminal Court said, yes, it does look like there's been some war crimes committed, and they, in fact, set up a separate tribunal under the auspices to prosecute those war crimes. Slobodan Milosevic and so on got taken into custody and ultimately tried by that International Criminal Tribunal that was established. So that's the sort of process they go through. You have a chief prosecutor. Karim Khan is currently the chief prosecutor of the ICC. The chief prosecutor, either off their own initiative or on complaints, will look at a particular issue and see, is there sufficient evidence to warrant taking the matter before the court. So well-known example where the system worked really well within almost a record time, because often these matters take a decade or more from when these crimes are committed. But in the early days after the Russian attack on Ukraine, Russia was removing Ukrainian children from Ukraine and making very public statements that we're taking these children away from Ukraine so that they can have a bright future under Russian guidance rather than these terrible Nazis in Ukraine who are bringing them up badly. So there was a quite systematic and deliberate removal of children to take them away from their cultural background in Ukraine.
And this was something, because obviously there's the as alleged point, but that's something that Russia itself was saying it was doing.
Yeah, and
it wasn't sort of an
Karim
accusation.
Khan actually says, look, it's very often difficult to establish in the absence of information and admissions what's going on, but in this particular instance, it was public statements by the Russian government saying we are doing this for this reason, that they were able to very quickly say, well, under the Genocide Convention, that actually is an act of genocide, forcibly removing a population to essentially destroy their culture. And so on that basis, within about 8 months, the ICC had issued arrest warrants for President Putin. You have clearly, there's a case to answer about whether this act of genocide has been committed by removing Ukrainian children from their cultural environment.
Well, then we have another legal question, don't we, which is the president in the person's official capacity as the head of state versus the person in their individual capacity. And is it a crime? Is the crime committed by the state, and therefore the head of the state is the person that's sought to be arrested, or is it committed by a person in their capacity as a person committing a crime?
Yeah, so under the Rome Statute, there's individual liability that attaches to, inverted commas, the senior managers and leaders of a state.
Okay. In those capacities as officials of the state.
Yes, so if you're able in your capacity to influence and control the state, then you'll have personal liability. So it really is only the very top tiers, the president or the equivalent in other states, or perhaps the minister in charge of a particular area, so a defence minister. So someone who is effectively the controlling mind of the state when it comes to those actions. So it's a similar concept in domestic law to when does a director take on personal liability for the actions of a company. Well, effectively when they're the hands and feet and controlling mind of the company, that director can have personal criminal liability for the actions of the corporation.
Even if they don't actually have the title.
Even if they don't actually have the title. So if you're the controlling hands and feet, in fact, you can be affixed with liability for the conduct of that corporation. If you're the controlling mind, the hands and feet of the state, you can be affixed with criminal liability under the Rome Statute for those actions.
And so just to be clear, is the Rome Statute derived again back from the United Nations Charter? That's all sourced from there originally? Or
so the Rome Statute's a separate treaty that was established to establish this international criminal regime and to establish the International Criminal Court. Again, one of the glaring omissions from the Rome Statute is the United States, who've said we will not allow other nations to judge our conduct. So the United States has quite pointedly refused to be part of and sign up to the Rome Statute.
Criminal Court,
Australia, on the other hand, we're party to that Rome Statute, and we accept that that's the way things should be. But it comes back to that first point about how does international law work? Well, you're only bound by it if you agree to be bound by it. And so one of the current hot topical issues in the world is the ICC has issued an arrest warrant for Prime Minister of Israel. They believe that there is a case to answer. Israel is not a party to the Rome Statute. And Israel says, therefore, you've got no jurisdiction to be issuing an arrest warrant for us because we're not party to that. So it's a very complex legal issue as to whether or not they do. The United States has taken the view that the ICC does not have the jurisdiction, the power to issue that arrest warrant. That's an untested area, but it's certainly a hot topical issue. Jurisdiction can arise in different ways. And one of the key issues that some of the European countries have said, well, yes, they do have jurisdiction, is if the conflict, the action is taking place outside of Israel, are you liable for things that happen outside your state, even if you as a state have not accepted jurisdiction? So that's a matter the court, the ICC, will ultimately have to deal with, is what's the jurisdiction of the court to be able to deal with it. The preliminary view that they expressed when issuing the arrest warrant was, yes, we think we do have jurisdiction on this.
So there's that element of jurisdiction. Is Russia a party to the Rome Treaty?
That is a good question. I'd have to check up on that.
Okay, because I wonder, just back to that.
Ukraine is
the issue of the arrest warrant to
Putin,
the president of Russia, whether, which brings in a whole new question of, you hear publicly, well, no, he no longer travels. So you can have an arrest warrant, but the only way in which you become affected by that is if you actually agree, in effect, to be in a position in order to be arrested, rather than in my territory, I can't be arrested, so I'll stay here type of thing. That's another tension in the international law.
That is. And I think the basis for the arrest warrant against President Putin was these crimes took place in Ukraine. When the conflict with Russia first started, the Ukrainian parliament very quickly said we vote to become party to the Rome Statute, so that it does have jurisdiction over territorial jurisdiction over Ukraine.
Yes.
And I think, but I'd have to double check, I think that's the basis on which the ICC accepted that there was a jurisdiction because these alleged crimes occurred in territorial area of Ukraine, that gave rise to the jurisdiction.
Okay. So I'm just thinking now, these are incredible concepts, and for me as a former law student 25 years ago, they're the sort of things that are extremely easy to forget just in life and also in daily practice. So back now to your job as an ADF officer, how do these concepts sort of affect the way or affect your job and what you do as a member of the ADF?
Absolutely critical foundation matters that ADF legal officers have to be aware of. Australia takes a very strong, robust position that of absolute paramount concern is compliance with international law. So we go to extraordinary lengths to make sure that anything Australia does is absolutely compliant.
Okay.
And Australia has a huge interest in making sure that international law is upheld because, as we said at the start, it's a middle power. Australia, we don't have the missiles, the aircraft, the bombs, the means of enforcing our thinking by military force
on others.
We rely on international law to safeguard Australia's interest. So it is not possible for Australia, on the one hand, to be saying, "Oh, we'll ignore international law when it doesn't suit us," and we expect international law to come in and protect our interest when it does suit us. So Australia has a very consistent, a very strong position that we will absolutely comply with, to the letter, with international law requirements.
So how then over a year, where you might spend 7 hours or 10 or 15 hours a month in your role as an ADF reserve legal specialist, how does that work out in your day-to-day job?
So it depends on which areas. So this sort of international law, or what we call in the military operations law, is only one aspect. A lot of the job as a reserve lawyer is dealing with the other two key areas, which are administrative law. So the law governing government decision making is very important and is probably for most lawyers, what affects their day-to-day job more than anything else is complying with standard administrative law practices.
For example, can you give me an example?
Whether a decision made is lawful, so challenging it under the Administrative Decisions Judicial Review Act. If someone is aggrieved about a decision, making sure that inquiries that are being conducted are conducted according to the rules of procedural fairness.
And this now, though, is within the ADF.
Within the ADF.
Not vis-a-vis anybody externally. It's entirely to do with the operation internally of the Defence Force.
Yes.
And its management.
Yeah, absolutely. So people in the Defence Force have a right to challenge decisions as any other citizen does.
Yes.
If a decision is made that a defence member believes adversely affects them, according to the principles of administrative law, they can challenge those decisions.
Yep.
There's both internal processes and sometimes things spill over into the civilian courts. So quite often there will be action taken in the federal court challenging a particular decision. The other big area internally in the military is military discipline law. There's an act of the Commonwealth Parliament, the Defence Force Discipline Act, which looks and feels and smells like criminal law. A lot of the things in there are things that would be ordinary criminal offences, but they also have a discipline aspect, which is what gives the Defence Force the jurisdiction to step in and deal with it. So some of them are purely military offences.
Yes.
Things like being absent without leave and so on. Others have a criminal law counterpart, such as assault.
Yes.
And indeed,
in that event, though, if there's an assault within a military context by a person or at least an allegation of, that's going to be dealt with internally rather than under a state law, or
it depends.
Okay.
So sometimes it's dealt with internally,
yes.
Particularly in matters that have a discipline consequence or effect on a unit, versus perhaps something that may not be significant enough for the civilian police to warrant looking at. So if someone, if a corporal came in and shoved and pushed over a sergeant who fell over, and hurt himself, the civilian police could go, well, look, it's not something, shoving someone, pushing them over is not right, but we probably wouldn't put police resources into taking that person to a civilian court. But it does have a severe impact on internal military discipline.
And morale, I guess.
And morale, if you have subordinates who are effectively thumbing their nose at their superiors and pushing them over. So that would be prosecuted as an internal Defence Force discipline offence. So you've got those two other areas, the administrative law aspects for just ordinary government decision making. You've got the discipline law aspects for that internal quasi-criminal code that applies to defence members. And then you have what we've been talking about so far today, the operations law area. And so for lawyers who are involved in roles in jobs involving operations law, all of the things we've been talking about are just bread and butter, day in, day out sort of things. So, for example, a military lawyer might be asked to advise on, I'll pick an example that's currently topical, was announced by the government a month or so ago. Australia is sending aircraft support across to Europe to assist in monitoring airspace over Ukraine. So we're sending one of our AWACS aircraft, our airborne early warning aircraft, across to Europe to assist in the protection of Ukraine by providing a battle airspace map of what's going on in live time.
Greater insight for the Ukrainians in terms of their own defence.
Greater insight for the Ukrainians, detecting incoming threats and so on to Ukraine. In order for the government to reach a position on agreeing to deploy, there's all sorts of complex operations law or international law questions about Australia's ability to operate, what's the legal basis for us to be able to go there, what can we do, what are the limits, what are the boundaries, what can aircraft there do in self-defence. Those become very live issues. So things like we were talking before about UNCLOS, the United Nations Convention on the Law of the Sea, which also then has a flow-on consequence to the law of airspace, of who owns what and what your rights are. Simple matters of, can aircraft operate over international waters?
Well, can I stop you there? Because when you and I first spoke a couple of months ago about this conversation, we were chatting at dinner about the movie The Eye in the Sky.
Yes.
And that's sort of anecdotally something that I think many listeners hopefully will have heard of or seen, or if not, as a result of this, may go and watch. But it's a fascinating example of the use by one state of a drone, or where the pilots are based in one state and the drone is flying over another state. And the eye in the sky is the little wasp that's flying around inside a room unbeknownst to people accused of threatening a terrorist attack. And it's all about the decision-making, the political and the military decision-making tension in respect of a drone attack on a single building in which it's alleged there are prospects of criminal conduct, and an innocent 12-year-old child who's out the front of that building selling bread for her livelihood. So we spoke about that. Can you sort of share how that metaphor plays into your job on a daily basis, or the military job, I should say?
Yeah, so that's a very good example of the targeting process, as it's called, in action. Unfortunately, the lawyer in that film was a bit of a wimp, and he should have been a lot more positive in what he was saying. A lawyer's job is to declare or to inform the commander as succinctly as possible what's legal and what's not legal, to draw the sort of left and right of arc. And it's then a decision for the commander. But if the commander is going to make good decisions, they need to get given clear statements of the law.
So on that though, just being clear that who is the commander? Is the commander the chief of the defence force who ultimately makes the decision, or is it the politician, being the president, or a political figure within the
So the
state?
commander is the military commander, who has been given generally delegated authority to carry out particular operations. So the government will direct the chief of the defence force to carry out a particular mission.
I see.
The chief of the defence force will then delegate that authority to a commander. Typically, all operations that Australia is involved in are under the direct command of CJOPS, the Chief of Joint Operations, who's a 3-star general who sits just outside Canberra in the Joint Operations Centre. CJOPS has responsibility for carrying out those missions. CJOPS will often then appoint a subordinate commander to do the day-to-day hands-on tasks for that particular mission. So it'll be the person who has the delegated authority to make a decision about whether to go ahead with an attack, to plan attacks and so forth. So in Eye in the Sky, it actually does demonstrate what the key considerations are. So these considerations come out of Additional Protocol 1 to the Geneva Conventions. The Geneva Conventions of 1949 are a set of 4 conventions that were set up following the horrors of World War II to try and primarily alleviate the suffering of civilians, unnecessary suffering of civilians. So after World War II, the world at large said this was just awful. It wasn't just the military combatants who were caught up in this. It was all of the millions and millions of civilians who were injured and killed and their lives made miserable. So a key objective of the Geneva Conventions is to try and minimise the suffering of civilians. The Geneva Conventions, written 1949, have been updated. There's Additional Protocol 1, which deals with international armed conflicts, was agreed in the 1970s, 1980s. Additional Protocol 2 deals with non-international armed conflicts, essentially internal armed conflicts within countries. So Additional Protocol 1 sets out what is so widely accepted that many legal scholars would argue it's now become customary international law, whether or not you've actually signed up to Additional Protocol 1. But it sets out the two fundamental principles governing the use of armed force in an attack. So the first principle is an attack must distinguish between military objectives, which are valid and allowable, and civilians and civilian objects, which are never allowable. You are never allowed to target a civilian or target a civilian object. Well, people say, well, how come all these hospitals and civilian objects get blown up all the time? They're not allowed to be the target. They can't be what your focus is. So a military objective is something whose nature, use, position, etc., give it, or the destruction or disabling of it, give you a definitive advantage in the war. So there's got to be that first step of distinguishing. Is what we're going after a military objective?
And in that case, in that movie, the prevention of a terrorist attack or a bombing of, I think it was either a shopping centre or a neighbourhood area, the prevention of that, which has further collateral damage of civilians, was the military focus.
Yeah, the military focus was taking out, in that fictitious movie, was taking
Good
out
metaphor,
a British citizen who was thought to have engaged and be likely to continue engaging in various terrorist attacks. So they wanted to take out this particular known individual who was a British citizen. So Britain was targeting that individual, which is why the surveillance was taking place in the first place. They tracked this individual, and it was a chance to take out the terrorist, to stop him participating in future attacks. The complicating thing in Eye in the Sky was, as they'd identified this particular terrorist and wanted to take him out, what they hadn't known was that there was what appeared to be an attack on a nearby market in the final stages of preparation. They were assembling suicide vests for the accomplices to this individual to go into the local marketplace and potentially kill hundreds of people with these suicide vests. So it became quite imperative, not just for taking out the individual, which was the initial aim of the mission, but became imperative to stop it there and then at potentially greater cost in order to stop these hundreds of lives being lost.
So it's sort of a dream case study.
And it brings in the second aspect of targeting. The first one we've talked about is distinction. Must distinguish between military objectives, which are valid, and civilian objects, which are never valid as the object of the attack. The additional protocol requires a state to take all feasible precautions to prevent incidental loss of civilian life or damage to civilian objects. So you've got your military objective, you've worked out, we're going to take out, in the Eye in the Sky example, this particular terrorist. That's your military objective, to take that person out. You've then got to have the next step is, well, what do we need to do to make sure when we take him out that there's no incidental damage to civilians or civilian objects? So there's a lot of things that you can do. Some of the classic examples, you can plan the time of day. So, for example, if we'll move away from Eye in the Sky to some simpler examples, if you wanted to take out a munitions factory that was full of workers, civilian workers who aren't potentially military objectives. So these civilian workers who are working in a factory, how can you minimise the loss of life for them? Well, if they work during the day, then blow it up in the middle of the night when there's not likely to be people there.
That is actually a deliberate process of thought in order to work out how to achieve the objective. Both objectives, the distinction and then making sure that the loss of civilian life is minimized.
We haven't come to that one yet, so we're still at the first one. So taking all feasible precautions, so military objective, all feasible precautions, and we'll come in a moment to proportionality. So all feasible precautions have to be taken, picking the time of day, picking the type of weapon to use. So, for example, if a 250-pound bomb would be sufficient to take out this factory or to stop it operating, don't use a 2,000-pound bomb, which might have a huge blast radius and take out lots of neighbouring buildings. So picking the weapon, picking the time of day, sometimes picking the attack direction, so approaching it from particular directions. Bombs are more likely, for conventional bombs, unguided bombs, to overshoot or undershoot. So it's likely that if you do miss the target, you'll miss it on the other side of your line of attack or this side of it on the line of attack. So if you've got things that you're trying to protect, don't have them in the line of attack, come in the other direction.
Yes. Yep.
So that your left and right is much more likely to be accurate. So there's all of these sort of things. So one of the jobs of a lawyer, when there's an attack planned, the lawyers are very much part of the planning process. The lawyer's going through and saying, well, have we satisfied all these things? Have all the feasible precautions been taken to minimise the likelihood that there'll be incidental loss of life or damage?
And actually, so there is a distinction then between the legal analysis in all of that respect and then just the tactical analysis of, well, you wouldn't want to waste a 2,000 pound bomb when you can use a 250. That's a sort of a cost-benefit analysis. But what we're talking about is that might occur anyway, but it's actually part of the overall legal analysis that you would be involved in.
Yeah, I mean, these processes are so well established it wouldn't happen in real life. But for example, if the military said, well, we want to use a 2,000 bomb just to be sure, the lawyer might say, oh, hang on, if we do that, have we taken all feasible precautions to minimise the incidental loss of life and damage? And look, and ultimately that's a decision for the commander. The commander might say it's not feasible because it's so important we get this, we'll only get one go at it. If we use a 250-pound bomb, it's probably going to work, but it might not, and we'll never get a second shot, so it's not feasible. So that's not a legal decision, but it's the lawyer's job to say, we have to take all feasible precautions. Whether they're feasible is an operational question. But it's our job as a lawyer to highlight that you've got to take these feasible precautions. Some of the other feasible precautions might be if you've got control of a territory, you might set up roadblocks. We know we're going to blow up this thing, so we'll set up roadblocks. Or as we've seen in some of the current conflicts, a country might send out leaflets and radio announcements that all civilians should leave this area because we are going to conduct military operations here. So that's part of the all feasible precautions, is if you can alert the civilian population to evacuating the area, that's going to minimise the likelihood that they'll suffer loss of life or be injured as a result of that. So that's the first step, the military objectives and the all feasible precautions. Then the next test that comes in this sort of two-part test is a test they refer to by the abbreviation of proportionality. If, despite taking all feasible precautions, it's not possible to completely avoid damage to civilian objects or incidental loss of life or injury to civilians, then that incidental damage, that loss of life, needs to be proportionate to the value of the military objective. So essentially, the more valuable, the more important the military objective is, the more incidental loss of life or damage, or what's referred to colloquially as collateral damage, the more collateral damage that you are able to justify. And that's the big grey area in the law of targeting and under Additional Protocol 1, is there's no formula. There's no exact number. It's a decision for the commander. Well, I think this is a really important target, so I'm prepared to accept a lot of collateral damage because this target is so valuable. So that's, again, where the lawyers have a role but not the ultimate role, is if, despite all of the things, all of the steps you've taken, choosing the right weapon, picking the time of day, if your damage estimate, and there's a whole methodology that sits behind it, it's given the name CDEM, Collateral Damage Estimation Methodology. So if you've carried out your CDEM, and come up with this is what we think might be the incidental collateral damage for the attack. It's then a decision of the commander. Is that justified? Is that proportionate to the value of the military objective? So an eye in the sky, those who've watched the film will remember they've worked out they're going to use some missiles, I think some Hellfire missiles from memory on a drone to take out the terrorist, the baddie. And they've worked out he's in a particular room in the house. If we send the missile in there, what's the CDEM radius? And in the film, which is actually reasonably indicative of the way the methodology works, you end up with a radius. So everything within a 20 or 30 metre radius, any object in that radius will be destroyed. Any person in that radius has a greater than 50% probability of being killed. So you work out what the likely collateral damage is. And it's important to recognise it's just an estimate.
Yes.
And it's a methodology, it's not a certainty. And you can't say, oh, well, if you're outside the CDEM radius that you'll be okay. And if you're inside, you'll definitely be taken out. It's just an estimate. It's the best guess of what the likely effect is. For things like bombs, it's very much affected by what's the structure made of. Is it concrete? Is it steel? There's a whole lot of things that will go into it. If it's a closed structure with closed doors and windows, then the blast tends to damage more than if it's a relatively open structure. So if you had a hut with open sides, no walls, it's not going to be damaged as much.
There's less to be moved, blown apart. Yeah.
So the forces tend to dissipate. So it's only an estimate. And in Eye in the Sky, they knew from the drone that was overhead that there was the little girl who'd set up a table just outside this building where the terrorist was. And their initial methodology was if we put a precision-guided munition directly onto the spot where we know this terrorist is currently sitting through our little micro surveillance drone,
the Wasp or the Bee or the Bee.
The Bee that was inside that was sending live time video feeds back. We know exactly where this person is. If we put a bomb exactly on that position, the little girl is inside the CDEM radius. And their particular rules of engagement appear to have been that they couldn't accept any collateral damage. So they had a zero limit on how much incidental loss of life of civilians there would be. In that movie, the pilot, the United States pilot who was operating the drone from a shipping container somewhere in the desert in the US, he said, no, I can't fire. No, I can't let the missile off because...
And theoretically, on everything you've explained, because within that analysis would be that it's not a very, very substantial military operation. It's a tactical approach on a daily basis that might be sought to be achieved, but it's not a very, very significant thing. So the proportionality is down.
Yeah. So
implicitly.
For all conflicts you have, if you think of it as at the top level, you've got the law of armed conflict, the laws of war that will allow certain things. For a specific conflict, states create what they call rules of engagement, ROE, and ROE must always necessarily be a subset or must be smaller than what's permissible at law.
Yes.
I'll say for a particular conflict, we set these rules. And so it would appear in the Eye in the Sky scenario that they had a acceptable civilian casualty level of 0. We won't accept civilian casualties without higher authorisation. So the pilot, the operator, aware of these rules of engagement, I can't engage.
I'm not allowed to.
I'm not allowed to because
this is what I've been told and this is my responsibility and I need a different level of approval to do anything else.
You need a different level of approval in order to be able to launch this missile. So what they did in Eye in the Sky, which is not proper practice and the lawyer should have said no, was deliberately to change the aim point of the missile and said, well, look, if we aim it at the other corner of the house, the baddie, the terrorist, will still be in the kill zone, in the radius where anything within that radius is likely to be destroyed, or people in that radius likely to be killed. They moved the aim point and said, if we aim not as we should be aiming for the purpose of this calculation, what will that do? And so by using that technique, they were able to say, the little girl selling bread is just outside the radius, so it's okay to go. And as actually happened in the film, the radius is just an estimate, and sadly the little girl did die, even though she wasn't in the zone where there was a 50% or greater chance of mortality.
Well, there was also a conflict there, wasn't there? Because at one point she wasn't there, and then just as the approach of decision-making occurred almost instantaneously or within a few seconds, she came back. And
that was an example of all feasible precautions. So a feasible precaution was to get her out of the area, and the way they tried to do that without compromising the mission was they went over and bought all of her bread.
Yeah, to distract her. Yes, exactly.
So once she'd sold all of the bread, she had to leave. They thought, great, she's now out of the way. We don't have to consider this as possible collateral damage. Unfortunately for the little girl, she's, great, I've sold all my bread for the day. She raced off home to get some more and come back. And so then just about at the moment when they went to reinitiate the attack, she'd come back and was selling bread again. So very unfortunate that was the way that played out. But it's a good example of taking all feasible precautions.
Yes.
What can we possibly do? Well, getting her out of the area, that was a feasible precaution. And you remember the debate that was going on in Eye in the Sky, where you've got the commander, the brigadier, played by Helen Mirren, making the decision back in London, in a government headquarters, watching all of this playing out in live time with the video feed, with the Minister for Defence there in the room, with the chief of their equivalent of the chief of the Defence Force in the room with them, trying to get through to the Foreign Minister, to the British PM, trying to get through to the US to get authorisation for this mission, given that this is a possible consequence. So it's a good example of how the process is supposed to work. And unfortunately for the profession of lawyers, if the lawyer in that film had done a better job, perhaps it wouldn't have had that same outcome.
So it's sort of this as extraterritorial conduct, as I would call it. Two states, the US and the UK, effectively formulating and implementing a strategy outside of their territorial boundary, basically. And there's so much of that going on in the world at the moment. So I'm curious about the law in relation to conduct where a state, and it's even in the paper today that it's happening here, as much as I'm sure it's happening elsewhere. States sending operatives or bands of people, whether they're military or political, or to other states to inquire and sort of operate behind the scenes to gather information and intelligence. Is there any law around that you, as a member of the ADF, is involved in giving advice in? Or is it sort of just, or am I just watching too much in the films?
So the ADF will give advice about ADF operations. And ADF operations, as I said before, we're very careful to make sure that everything the ADF does is absolutely 110% in accordance with international law. So there will always be a whole lot of legal work that's done before any operation. So deploying an AWACS aircraft across to Europe to assist, there's a whole lot of legal analysis that's done. What's the lawful basis? And in that case, it's if the host nation invites you, you are able to go across at the invitation of that nation. And indeed, that was the basis for some of the other conflicts we've had in the last 20 years. Australia's position on the conflict in Syria, going in against ISIS, was we were there at the invitation of the Iraqi government to participate in the collective self-defence of Iraq from these ISIS attacks coming in from Syria.
Yes, so that's an invitation, and then there's the distinction between that and states sending operatives undercover to operate?
Yeah, so operatives undercover to operate is outside of defence. So there's Australia's agency is AUKUS, the Australian Secret Intelligence Service.
Okay, so it's a completely different group of people.
It's completely different. It's governed by the Intelligence Services Act. It's a different organisation. Up until I think it was about the 1970s, their existence was a secret. The government would not confirm or deny. Since then, AUKUS is now, the government acknowledges it. In fact, they've got a public website people can go to, aukus.gov.au, and you can read on their website exactly what their mission is, in very broad terms, what they do. Of course, they don't give away, by the nature of the work they're doing, they don't give away the precise details of particular missions, but AUKUS's job is to have Australian operatives or other sources bringing in information about foreign countries that would not otherwise be available to Australia.
Okay.
And so if you want to understand what their left and right of ARC is, you can go and have a look at their website or read the Intelligence Services Act. There's parliamentary oversight. The Parliamentary Joint Committee on Intelligence Services is responsible for oversighting what AUKUS does, and there's also an Inspector General of the Intelligence Services who has the responsibility of monitoring exactly what they're up to. And you can imagine that where you've got organisations that have to operate necessarily with a high degree of secrecy, it's very important to have strong accountability measures in place to make sure that they are behaving as they ought to behave.
Which brings me, there's probably two or three more small subjects, which are large subjects, but try to cover them shortly, is war crimes. I mean, obviously there's been a huge amount of media about defamation trials that arise from allegations around conduct by our soldiers in foreign states. How does if we take the Ben Roberts-Smith example, where that is a defamation case, but there's sort of findings in a sense around conduct that might constitute war crimes and that might result in ultimately prosecution. But if you look at that and then you think about the internal machinery of the ADF and the punishment, for example, of that type of behaviour, can you give us any insight just into how war crimes might be identified and punishable within the force, as distinct from outside and through, the type of media we've seen through defamation claims?
So that's probably a good example. So if you look at the background to the alleged war crimes, or I suppose the war crimes that have been established on a civil basis, that is the balance of probabilities, there were rumours in the early 2010s that things had not been done the way they should have been done in Afghanistan.
Rumours, you mean just socially within Australia or within the Defence Force or just everywhere?
Within the Defence Force, coming from Afghan citizens, socially in Australia, there were gossip that things maybe weren't being done correctly.
Okay.
These rumours then escalated, became more persistent, things are not right. The then Chief of Army, Lieutenant General Angus Campbell, decided to appoint or request that the Defence Force Investigation Agency, the Inspector General, have a look at this to say, well, look, there are these rumours. I want someone to go in and have a proper investigation, have a look at, is there any substance to these rumours? The Inspector General of the ADF is a statutory position that's set up to oversight these sort of matters inside the Defence Force. The Inspector General is not a member of the Defence Force. It sits effectively outside. It's the independent...
Like an ombudsman.
A bit like an
ombudsman.
Yep. There is separately a Defence Ombudsman, but the Inspector General is a sort of ombudsman plus, has inspection investigation powers that go beyond what an ombudsman would normally do. The Inspector General appointed Major General Paul Brereton.
Yes, who we know well.
Who we know well. Before him.
Know of well, I should say.
Know of well.
I've appeared before him too, yes.
Yes. He's was also at that time a judge of the New South Wales Supreme Court, later became a Justice of Appeal in the New South Wales Supreme Court. Separately, he was a reservist in the military, in the army as a Major General. So Major General Brereton was tasked on behalf of the Inspector General to conduct an investigation into these allegations. And that took some 3 years or so that Major General Brereton was looking at these matters, interviewed hundreds of people, conducted a very thorough investigation, and as a result of that investigation came out with the Brereton Report, or which the Inspector General points out, everyone calls it the Brereton Report, but it's actually my signature on that report. Major General Brereton conducted it on my behalf. So the IG's report, or what's known publicly as the Brereton Report. So that's a typical example of how these sort of things might come to light. If rumours are starting to circulate, if people are saying things as it becomes or it gets to the notice of people at a sufficiently senior level, they will then take steps to find out, well, look, are these rumours that we're hearing, is this gossip correct? And that's what happened in those war crime allegations that were made. It really shouldn't happen that way. So first of all, our people should not be committing war crimes. As part of our obligations under the laws of armed conflict, our obligations to the United Nations, Australia conducts thorough law of armed conflict training, both generally when people are first join up to the Defence Force and specifically before they go on particular operations, to make sure they understand what the laws of armed conflict are. So there's essentially no excuse. Every Australian soldier, sailor, aviator has been given training in what the laws of armed conflict are.
And then what the laws of conflict are is also embraced within domestic law and the Commonwealth Crimes Act. Those are actual criminal offences by Australians to do that, even if they're in a war environment.
Yes. So the Commonwealth Criminal Code incorporates lots of the laws of armed conflict, lots of the obligations that arise have been codified in domestic law. You remember we said much earlier in this podcast that international law has to, in Australia, be legislated domestically to become part of domestic law. It doesn't automatically apply. So these sort of international crimes are now part of Australian domestic law in the Commonwealth Criminal Code, and so are binding on Australians. But some of them you'd like to think you wouldn't have to think too hard that those things are wrong. So if you've got a prisoner who's handcuffed, you don't kick them off a cliff. There are all sorts of, in the Geneva Conventions, in the additional protocols, the treatment of prisoners is highly regulated. And once someone is outside of the battle, hors de combat, as it's called, a French expression, once they're out of the fight, they are no longer a lawful target. You can no longer lawfully kill them.
So, but a person at the accusation of a commission of a criminal offence that constitutes a war crime is something that's going to be most likely prosecuted by the Commonwealth Government.
Absolutely.
More likely by them in the end than the Defence Force.
Yeah, so Defence Force jurisdiction under the Defence Force Discipline Act we talked about before, there's got to be a nexus, a link to discipline. So that's where the constitutional authority for the Defence Force to be prosecuting these things internally comes. There has to be a connection to Defence Force discipline because constitutionally only a Chapter 3 court under Chapter 3 of the Australian Constitution can exercise judicial power, the determination of guilt, the handing out of punishments and so forth. So it's a very nuanced area, but the High Court has said for a number of cases that the Defence Force only has jurisdiction to investigate and deal with things that have a nexus to Defence Force discipline.
I see.
If it's just an ordinary crime, you go and set fire to someone's car or burn down a building, If it has no connection with your defence service, it's just simply a crime that you've committed separately and you just happen to be a defence member, defence is unlikely to have jurisdiction to investigate it. So the discipline aspects of committing war crimes, while there are certainly some, and it's not good for discipline, and indeed the alleged war crimes in Afghanistan caused a great deal of angst and heartache and upset amongst internally trauma of morale and so on. So it does arguably have a discipline aspect, but far more significant is it's an ordinary, very serious crime. It's the crime of murder under the Commonwealth Criminal Code. The Defence Force has protocols, how they operate with the DPP, the Director of Public Prosecutions. We have a DMP, Director of Military Prosecutions. The DMP and the DPP work very closely in these sort of serious matters, and there's all sorts of protocols we follow about what we will look at internally versus what will be dealt with externally. But something as serious as a war crime, absolutely that's something the DPP will look at. The investigative arm for civilian crimes is the Federal Police. And there was, with the investigations that came out of the Brereton Report, a difficult issue which derailed the investigations. So in brief compass, that difficult issue was Major General Brereton, under the IGADF regulations, has or had the ability to compel evidence from witnesses. It's actually a criminal offence to refuse to answer questions or fail to comply with a direction to produce an object, for example. So Major General Brereton extensively used his powers of compulsion to force people to give evidence. The Commonwealth Parliament decided, as a trade-off, as it often does in these cases, if you're compelled to give evidence that might incriminate yourself,
you have a certificate against self-incrimination.
You get a certificate against that evidence you've given being used against you subsequently. So it's always very difficult that the policy objective is it's so important to get to the truth of what happens. The Parliament's decided that warrants overriding this protection against self-incrimination. Otherwise, you'd be able to say, I'm sorry, Major General Brereton, I choose not to answer that question.
In which case the whole thing is pointless. And
then you don't get anywhere. So the government, the Parliament decided that it's more important to be able to get to the truth. So the trade-off was, no, he can force you to answer questions against threat of, ultimately you'll go to jail if you don't answer the questions. But the trade-off for that is we can't use that evidence against you in a criminal prosecution. It means you've got to be supremely careful to make sure that anything obtained through compulsion does not spill across into the police investigation. And there was, during the early days, the initial inquiries being made by the Federal Police, they're part of their initial investigation, was contaminated by some of the material that had been obtained under compulsion.
Which
derailed that initial criminal investigation. What the government then did was set up a separate body, the OSI, the Office of Special Investigation, headed up by Justice Weinberg from the Victorian Court of Appeal, to start again afresh. And they've also set it up a body within Defence with a senior Defence Force lawyer working there to absolutely make sure that what information, what material can be provided to the OSI is provided, but to be a very careful gatekeeper to make sure that nothing is provided that might derail the investigation and might later lead to prosecution being stopped because material that could not be used has been used in order to get that information. So in practice, what that's involved is the OSI investigators re-interviewing people to get that information afresh where they can't compel answers. But if people choose to answer, that material, as with any normal criminal investigation, can be used. There's also the ability to use evidence that someone has given about what they saw and heard that's not self-incriminating, because you don't have that level of protection against it. So the OSI is moving very carefully, and some people complain, perhaps rightfully, that look, why is this taking so long? These alleged crimes took place 15 years ago, back in 2010, 2011. How can this possibly be justice that it's taking so long for these allegations to be tested? It's an incredibly difficult investigation. There are federal police who've been seconded to the OSI who are working on it, and they say this is the most complex police investigation that Australia has ever undertaken.
Wow.
It is made all the more difficult since the fall of Kabul, since the fall of Afghanistan back into Taliban hands. The availability of civilian witnesses is now almost non-existent to be able to go there and interview people. So ordinarily, part of what they would do is go and talk to Afghan villagers who might have witnessed things and gather evidence in the conventional way. That is extremely difficult to do. There are genuine fears for the safety of Afghans who are seen to cooperate with the West.
Of course,
are at real personal risk from the Taliban. So trying to piece together sufficient evidence to be able to prove beyond reasonable doubt that these offences took place is very difficult. We've got the first of the war crimes trials to come out of the OSI is currently before the courts.
Really?
Corporal Schultz is alleged to have committed war crimes. In a sense, they've probably picked the low-hanging fruit to start for the first prosecution. So the alleged war crimes of Corporal Schultz were captured on body cam.
Okay.
So you've got contemporaneous video footage, and those who watch the ABC and Four Corners, it's that footage is well known. People have seen that. So that's a relatively, compared to some of the others, straightforward prosecution.
Richard, I'm very conscious of our time. I'm sort of, it's being suggested, it's probable we've been talking for so long, and this might be a whole new subject because it's something that's, I think, going to be in the media, and perhaps we can talk about it again and the legal aspects. So what I just want to recognise is you have just spent over 2 hours with me, and you've done so very, very generously at your time. And, this is something you've been free and willing to give to people and me for the purposes of helping people understand international law and the job of ADF Reserve Legal Officers and your career. So may I just say thank you. It's been amazing.
Yeah, it's been very interesting.
Very enjoyable. And I just want to convey my heartfelt thanks to you, and hopefully listeners are going to be intrigued by everything you've been able to tell me.
So I hope so. Thank you.
You.